Hello, I'm Debojit Das, and you're watching Courts Today by LiveLaw, your daily roundup of the most important legal developments from across India. Today, the courts tackled a wide range of significant issues. So, let's get started. In one of the most important ongoing matters, the Supreme Court, hearing the Bihar voter list controversy, issued a major interim order today to secure the right to appeal. That is for excluded voters by mandating free legal aid. The bench, comprised of Justice Suryakant and Justice Joymalia Bagchi, requested the Bihar State Legal Services Authority to immediately direct district legal service authorities to mobilize paralegal volunteers and free legal aid counsels. These personnel must reach out to excluded persons, inform them of their right to appeal, their exclusion from the final list, and offer assistance to draft their statutory appeals and provide legal counsel. The court explicitly stated this benefit applies even if a person's name wasn't in the draft list. In a contentious moment, however, the ECI senior advocate Rakesh Dwivedi refuted an instance of alleged illegal exclusion cited by petitioner ADR, calling the supporting affidavit a false affidavit that amounts to perjury. Both justices reportedly expressed displeasure with ADR's lawyer Prashant Bhushan for apparently presenting unverified evidence. The ECI assured the court that a 5-day window remains for appeals and promised prompt decisions on all filings. Despite the contention over evidence, the court prioritized ensuring access to justice via the Legal Services Authority, with the matter set for next hearing on October 16th. The core idea from the Supreme Court's Constitution bench, which was a much-awaited decision, is a massive validation for in-service judicial officers. They essentially said the experience of an assistant public prosecutor or a government pleader cannot be considered superior to that of a judicial officer, and therefore barring these officers from direct recruitment is irrational. The judgment, authored by Chief Justice B.R. Gavai, emphasized that the experience a judicial officer gains, including at least a year of rigorous training, is much greater than that of a practicing advocate. The judges questioned the logic. If government pleaders who practice before these officers are eligible for direct recruitment, how can the judicial officers themselves be barred? The court strongly held that it is only merit and merit alone that shall matter, asserting that excluding talented officers violates Articles 14 and 16, that is, equality and equal opportunity. This explicitly overturns the 2020 Dheeraj Moore judgment, which had previously emphasized the fresh perspective an advocate brings. The new ruling ensures that experienced judicial officers are not denied the opportunity to compete for the district judge post. Staying with the Supreme Court, and this ruling touches on the sensitive area of reproductive rights and the effect of new legislation on ongoing medical processes. The case centered on couples who had already taken the substantial step of freezing their embryos before the Surrogacy Regulation Act of 2021 came into force. The new law introduced strict age limits, 23 to 50 years for the woman and 26 to 55 for the man. That is Section 4, Subsection 2. The new law introduced strict age limits, 23 to 50 for women and 26 to 55 for the man. The couples argued that their right to reproductive autonomy and parenthood had already crystallized when they created the embryos under the previously existing legal framework, which lacked these age restrictions. They contended that applying the new age limits retrospectively to their cases would deny their fundamental right to have a child. The union government argued against this, citing biological considerations for genetic equality and concerns over the welfare of the child, arguing older parents might be unable to provide long-term care. The Supreme Court, through a bench of Justice B.V. Nagaratna and Justice K.V. Vishwanathan, agreed with the couples. The court held that the age restriction does not have retrospective operation and will not apply to intending couples who commence the process, meaning had their gametes extracted and embryos frozen before the 2021 Act's enforcement. The court stressed that the state cannot substitute its own judgment on parental suitability for the couple's right to parenthood. Moving on to this shocking incident that occurred on October 6th when Advocate Rakesh Kishore attempted to throw a shoe at Chief Justice of India B.R. Gavai during court proceedings. Witnesses reported the advocate shouting slogans related to the sanctity of Sanatan Dharma as he was being escorted out of the security. The lawyer was reportedly upset over recent remarks the Chief Justice of India had made while dismissing a petition concerning a temple idol. The Supreme Court Bar Association, or the SCBA, took immediate and decisive action. The SCBA Executive Committee unanimously resolved to terminate his temporary membership with immediate effect, removing his name from the association's rolls. The SCBA strongly condemned the act as a direct assault on judicial independence and an unbecoming breach of professional decorum, emphasizing that such behavior constitutes serious misconduct against the dignity of the Supreme Court. The Bar Council of India also issued an interim order suspending the advocate from practice. Next, in this ruling that involves the critical matter of judicial independence and the treatment of trial judges by higher courts, the Supreme Court recently stayed a highly unusual order from the Madhya Pradesh High Court that targeted a special judge under the POCSO Act, Vivek Singh Raghuvanshi. The controversy stems from a criminal case where the trial judge, Raghuvanshi, relied on the scholar register to establish the victim's age, leading to a conviction. The High Court, however, overturned the conviction, relying instead on an ossification test report which suggested that the victim might have been an adult. Crucially, the High Court did not stop at acquittal. It made highly adverse remarks labeling the trial judge's conduct as intellectual dishonesty and negligence. The most severe order was the directive for a vigilance inquiry into the judicial work of Raghuvanshi's over the last 5 years. When the matter reached the Supreme Court, a bench led by Chief Justice B.R. Gavai immediately issued a stay on the High Court's directions for investigation and the adverse remarks. This intervention signals the Supreme Court's concern about higher courts imposing such severe, broad-ranging inquiries on trial judges, especially when the basis appears to be a difference in weighing evidence, which the trial judge argued was legitimate under established law, like relying on the scholar register and the medical report, and was not stressed by either side. This say protects the judicial officer from the stigma and administrative disruption of the extensive 5-year probe until the Supreme Court can fully examine the matter. An interesting case has reached the halls of judiciary. Imagine spending 3 years pursuing a degree and at the end of it all, you realize it isn't even the degree you thought you were enrolled in. The present case involves a student from OP Jindal Global University who filed a petition against the institution. The core allegation here: the university allegedly misrepresented its 3-year LLB program as an honors degree throughout the admission and course period. The petitioner argued that he and his batchmates were led to believe, based on the official prospectus and identity cards, that they were enrolled in an LLB honors course. Much to their surprise, upon completion, they only received a standard LLB degree. The university attempted to dismiss this, claiming the honors designation was a mere typographical error in all their official documents. The student countered, stating that university is legally estopped from changing the course description after inducing students to join. Taking the matter seriously, the Punjab and Haryana High Court has now issued formal notice to the Union Government, the University Grants Commission, and critically the Bar Council of India, demanding their response on this alleged misrepresentation of a vital legal qualification. And finally, this ruling from the Madhya Pradesh High Court is a powerful reminder to government bodies that the courts are not for adjourning cases, but for justice. The case involves the Gwalior Municipal Corporation, or GMC, which was pursuing a review petition. The key problem here: the GMC had failed for over a month to serve a notice to the opposing respondent, that was Gleg Engineers Private Limited. In an order a month prior, the court had already noted the original notice was returned without clear delivery. The GMC's counsel admitted the respondent was likely trying to avoid service and had successfully requested permission to use a substituted mode of service, specifically serving notice through a newspaper publication under Order 5, Rule 20 of CPC. The court granted 1 week to file the necessary application. Fast forward to the next hearing, despite the GMC's office being only about 3 kilometers from the High Court, the body had completely failed to file the application even after 1 month had passed. Justice G.S. Ahluwalia noted the corporation had shown total disregard for the court proceedings. The bench emphasized the courts are not meant for adjourning the case, just for the convenience of the parties. The court granted one final chance, but only on the mandatory payment of a cost of 25,000 rupees. Critically, the court ordered that this fine must be deposited by the officer in charge, or OIC, from his own pocket, ensuring it would not be reimbursed by the state. The High Court was making it clear the cost of bureaucratic negligence must be borne by the negligent official, not the public treasury. That's a wrap for Courts Today by LiveLaw. To access every single judgment and order mentioned here, please visit us on www.livelaw.in. Thank you for watching.